5 seconds to go. Start. Sir, the other day when I initiated the debate, I spoke only for 5 minutes, and during that time, I made a reference to Article 39 of the Constitution. I also submitted that in a period of 51 years of our independence, states could not implement the directive principles with reference to that. I also made a mention of the exception of the West Bengal government and the government of Maharashtra. I was discussing the question as to the necessity of the introduction of this particular bill. I said at that time that on many occasions we referred to the problems abroad. For example, when there is a price rise, it is usually said that there is a price rise in all countries and therefore we cannot help it. It is with reference to this I would also like to invite the attention of this august House and the Honorable Minister as to what is the position abroad. As far as this is concerned, if we have a look to other constitutions, a reference of which has been made to the constitutions of the world, we find there are about 21 countries in the world wherein this right to work has been recognized, and out of these 21 countries, China, Japan, USSR are there. Not only this, Ireland, from whom we took the inspiration for independence, has also included this right to work as a constitutional right. Not only this, but there are other countries also who, though have not included the right to work as a fundamental right in the Constitution, have provided for unemployment benefits. We find that there are about 28 countries which include Switzerland, Sweden, and Australia. It is because of this I would request the Honorable Minister for Law and Justice to consider the constitutions of these particular countries who have recognized this particular right, and then consider whether the time has not come after 51 years of independence, and especially when we could not implement the directive principles, whether the time has not come now to consider very seriously this particular problem as to whether this right should be enshrined in our constitution as one of our fundamental right. As far as our country is concerned, the government of West Bengal unanimously passed a resolution to this effect without exception of all the parties. As observed herein above, the learned arbitrator rejected claim number 4, namely under the head construction of railway siding. The award declared by the learned arbitrator came to be confirmed by the learned Commercial Court, Jaipur, in an application under Section 34 of the Arbitration and Conciliation Act. Feeling aggrieved, the respondent preferred an appeal under Section 37 of the Arbitration Act before the Commercial Appellate Court Division Bench of the High Court of Rajasthan at Jaipur. By the impugned judgment and order, the High Court has allowed the said appeal and has set aside the award passed by the learned arbitrator and confirmed by the Commercial Court, Jaipur. Feeling aggrieved by the impugned judgment and order passed by the division bench of the High Court, the original claimant, the appellant, has preferred the present appeal. The learned senior advocate has appeared on behalf of the appellant, and learned Solicitor General of India has appeared on behalf of the respondent. The learned senior advocate appearing on behalf of the appellant has vehemently submitted that in the facts and circumstances of the case, the High Court ought not to have interfered with the concurrent findings of the learned sole arbitrator and the learned commercial court under section 34 of the Arbitration Act by giving an alternate construction to the CMDA. It is vehemently submitted that by passing the impugned judgment and order, the High Court has exceeded in its jurisdiction in interfering with the award passed by the learned arbitrator, confirmed by the learned commercial court, while exercising the powers under section 37 of the Arbitration Act. It is further submitted by the learned senior advocate appearing on behalf of the appellant that under section 37 of the Arbitration Act, the scope of judicial inquiry is narrow and does not entail giving on construction to the contract. It is submitted by disturbing the findings. The High Court has gone beyond the limited scope of inquiry planned under section 37 of the Arbitration Act. It is further submitted by the learned senior advocate appearing on behalf of the appellant that the division bench of the High Court has failed to appreciate that the interpretation made by the learned sole arbitrator on the clauses of CMDA was plausible interpretation and therefore the same should be allowed.